Hello everyone, welcome to Tort Law video series. In this video, we will discuss about general defenses in tort law. General defenses in tort law are situations where a defendant can escape liability or reduce responsibility even though a tort has been committed. In simple words, the defendant admits that harm has occurred but argues that there is a valid legal reason why they should not be held responsible. These defenses can help courts decide whether liability should actually arise in a particular case. The main purpose of general defenses is to ensure fairness and justice. Sometimes harm may occur, but the circumstances may show that the defendant acted reasonably or that the plaintiff accepted the risk. In such cases, it would be unfair to impose liability. Therefore, the law recognizes certain defenses which justify or excuse the conduct of the defendant. These defenses are called general because they apply to many types of torts and are not limited to one specific wrong. They form an important part of tort of law because they balance the rights of both parties. Without defenses, a person might become liable in every situation where harm occurs even when it is not reasonable to impose responsibility. For example, if a person participates voluntarily in a risky sport like boxing or football and gets injured during the game, they usually cannot claim damages for normal injuries. This is because they accepted the risk involved in the activity and the defendant may rely on a general defense. Now let us look at voluntary non-fit injuria. The principle of voluntary non-fit injuria means that a person who voluntarily agrees to take a risk cannot later complain about injury arising from that risk. In simple words, if someone knowingly and willingly accepts a danger, the law will not allow them to claim compensation if any harm occurs. Consent acts as a defense for the defendant in such situations. For this defense to apply, the consent must be free and voluntary. The person should have full knowledge of nature and extent of the risk involved. Mere knowledge of risk is not always enough. There must also be willingness to accept that risk. If consent is obtained by fraud, force, or mistake, this defense will not apply. This defense is commonly seen in activities where risk is naturally involved, such as sports, adventure activities, or medical procedures. However, it does not protect the defendant if they act negligently beyond the accepted limits. The defendant must still follow reasonable standards of care. For example, when a separate spectator watches a cricket match, they understand that a ball may come into the audience. If they ask injured by a ball hit during normal play, they usually cannot claim damages because they voluntarily accept the risk. The next defense is plaintiff the wrongdoer. The defense of plaintiff the wrongdoer means that a person cannot claim compensation if the injury occurred because of their own illegal or wrongful act. In simple words, the law does not help a person who relies on their own wrongdoing to claim damages. This principle is based on the idea that courts should not support illegal behavior. For this defense to apply, the plaintiff's wrongful act must have a direct connection with the injury suffered. If the harm occurred as a result of the plaintiff's own lawful conduct, the defendant may avoid liability. Courts usually examine whether the plaintiff's behavior contributed significantly to the damage. The purpose of this defense is to discourage illegal activities and maintain respect for the law. If court allowed compensation even when a person was acting unlawfully, it would encourage irresponsible or illegal conduct. Therefore, the defense promotes public policy and fairness. For example, if a person breaks into someone's house to steal and get injured due to security measures, they generally cannot claim damages. The injury happened because of their own illegal act, so the law will not provide compensation. The next defense is inevitable accident. The defendant of inevitable accident refers to a situation where harm occurred without any negligence and could not have been prevented even by taking reasonable care. In simple words, the accident happened despite of all precautions, and therefore the defendant should not be held liable. The key idea is absence of fault. For this defense to succeed, the defendant must show that they acted carefully and responsibly. If a reasonable person in the same situation could not have avoided the accident, then it is considered inevitable. However, if there was any negligence or lack of proper care, this defense will fail. Courts usually examine the facts very closely to decide whether the accident was truly unavoidable. The burden is on the defendant to prove all the reasonable precautions were taken. This defense protects people from liability when harm occurs due to circumstances beyond their control. For example, if a driver is driving carefully and suddenly a mechanical part fails without warning despite proper maintenance and causing an accident, it may be considered an inevitable accident. In such cases, the driver may not be held liable. The next defense is act of God. The defense of act of God refers to the situations where harm is caused by natural forces that are extraordinary, unexpected, and beyond human control. These events occur due to natural causes alone, without any human involvement. Because such events cannot be predicted or prevented, the defendant may not be held liable. For this defense to apply, the event must be purely natural, such as earthquakes, floods, storms, lightning, or other natural disasters. It must also be something that could not have been reasonably anticipated or prevented by human care or the skill. If the event is ordinary or predictable, this defense may not be succeeded. Another important requirement is that there should be no human negligence contributing to the damage. If the human action combined with natural forces cause harm, the defendant may still be liable. Court carefully examine whether the event was truly unavoidable and extraordinary. For example, if an unus- unusually severe and unexpected flood destroys property despite proper safety measures, the damage may be treated as an act of God. In such situations, liability may not arise because the harm was caused by natural forces beyond the human control. The next defense is private defense. The defense of private defense allows a person to protect themselves, their property, or another person from immediate harm or danger. The law recognizes that in certain situations, a person may need to use reasonable force to prevent injury or to protect their rights. Therefore, action taken in self defense may be legally justified. However, the force used must be reasonable and proportionate to the threat faced. A person cannot use excessive force or cause more harm than necessary. If the response goes beyond what is required for protection, the defense may fail and liability may arise. Another important condition is that the danger must be real and immediate. Private defense cannot be used as an excuse for revenge or punishment after the threat has passed. The purpose must only be protection, not retaliation. For example, if someone attacks a person and the victim pushes the attacker to escape causes minor injury, it may be justified under the private defense. The law allows such actions because it was necessary to prevent the harm. The next one is necessity. The defense of necessity applies when a person causes harm in order to prevent a greater harm or danger. In simple words, the law may excuse a person's actions if they acted reasonably to avoid a more serious injury or the damage. The principle is based on the idea that sometimes it is better to cause a smaller harm to prevent a bigger one. For this defense to apply, the act must be done honestly and in good faith to avoid an immediate danger. The person should not act for personal benefit or convenience. Courts examine whether the action was reasonable under the circumstances and whether there was any other safer option available. Necessity is different from private defense because it does not always involve protection from another person. It may involve emergencies like fire, accidents, or medical situations where quick action is required to prevent serious harm. The law focuses on whether the action was necessary at that moment. For example, if a person breaks open a locked door to rescue a child trapped inside a burning house, the damage caused to the property may be excused under the defense of necessity. The law recognizes that the action was taken to prevent a greater harm. The next defense is statutory authority. The defense of statutory authority applies when a person performs an act under the authority given by the law or statute. If the law itself permits or requires a person to do something, then that act may not create liability in the tort. In such situations, the defendant can argue that they were acting according to the legal permissions. However, this defense applies only when the act is done within the limits of authority granted by the statute. If the person acts negligently or goes beyond what the law permits, the defense may fail. So, statutory authority does not protect careless or improper conduct. This defense is commonly used by public authorities and government bodies performing duties for public benefit, such as construction of roads, railways, or public utilities. Sometimes such activities may cause inconvenience or damage to individuals, but the law allows them if they are carried out properly. For example, if a railway authority constructs a railway line under statutory permission and nearby property suffers some unavoidable disturbance, the authority may not be liable, provided there was no negligence in the work. The protection exists because the activity was authorized by the law. The next one is contributory negligence. Contributory negligence occurs when the plaintiff's own negligence contributes to the injury suffered. In simple words, it means that the injured person was also partly responsible for the harm. In such situations, the law does not place the entire blame on the defendant but examines the conduct of both the parties. The main idea behind this defense is fairness. If both the plaintiff and the defendant were careless, it would be unjust to make only the defendant pay full compensation. Therefore, courts determine how much each party contributed to the accident and adjust the compensation accordingly. In modern law, contributory negligence usually reduces the amount of damages rather than completely preventing recovery. This approach is called comparative negligence. The court calculates the percentage of fault of each party and reduces compensation based on the plaintiff's share or responsibility. For example, if a pedestrian crosses the road without looking properly and is hit by a speeding vehicle, both parties may be negligent. The driver may still be liable, but the compensation awarded to the pedestrian may reduce it because the pedestrian also contributed to the accident. In the next video, we will discuss about negligence. If you found this video helpful, please like, share and subscribe. Thank you for watching.